So, this video today is going to be about intention to create legal relations. What you are looking at is whether the claimant and the defendant intended to be bound and actually want to enter into a contract. If we look first at social and domestic agreements, this is family members, friends, people like that. And we have the presumption and the rebuttal. A presumption is something that we assume to be the case. And a rebuttal is something that disproves that. So with social and domestic agreements, the presumption, we presume that any agreements made are not binding. So agreements between you and your family about tidying your room, that's not a binding contract. This can be rebutted, so disproved, where there is something more formal which indicates an intention to be bound. So let's look at some cases. Balfour and Balfour. In this case, the husband promised to pay his wife an allowance, and this was an agreement made whilst they were still married. When their relationship ended, he stopped paying, and the wife sued him, saying that he had breached a contract that they had formed. But the court said this is a domestic arrangement, and the parties hadn't intended it to be binding. This can be distinguished from the case of merit and merit. This was an agreement made between an ex-husband and his ex-wife as they were getting a divorce about the payment of their mortgage. This was written down and it was signed. And the fact that they wrote it down and they signed it showed that they had clearly intended it to be binding. So that's the situation with family and friends. If we look at business relationships, it's the opposite way round. We assume, the presumption is that any agreements made are binding, and that the rebuttal shows where there is a different intention clearly shown. And this different intention is demonstrated in the case of Jones and Vernon Pools. And in this case, there was a statement on the football Pools betting slip which said, "binding in honour only." This clearly indicated that it was only supposed to be binding in honour and therefore not binding in law. So this was clear enough to show that it wasn't intending to be legally bound. The final case we need to look at is a case called Simpkin and Pays, which is looking again at family relationships and friendship relationships. In this particular case, a granddaughter, their grandmother and the lodger, who all lived in a house together, entered a competition together. The grandmother had actually entered the competition for them, but they had all put in money and the answers together. The grandmother then refuses to pay the other two their share. And it was held that they were entitled to their share because their agreement was to the effect that, from the view of the court, when they entered the competition, they intended to make a binding arrangement, and therefore when they won the competition, it was also binding.
One last one more.